Test check 1, 2.
I know they redid the room, but I haven't seen the table. Yeah, it's a whole different yeah, I think it's intended to accommodate people who work here. Well, they changed it. You know, the thing is they put a new row down here, which took a bunch of room out of a bunch of seats out of the room, and they made the ramps more ADA compliant because they're more gentle, I think, in their flow.
The subcommittee will come to order. Good morning. I want to start by thanking our witnesses for being here today. As members of the Subcommittee on Workforce Protections, we greatly benefit from your expertise, and we appreciate that you took time out of your busy schedules to testify here today and walked in from beautiful weather outside as well. Representative Pocan and I were trying to figure out how we could do this outdoors instead of indoors, but protocol continues. There are many issues under our jurisdiction that touch workplaces across the country. One of the more important issues is employee health and safety. This is a challenging issue that directly impacts the lives of America's workers and their families, and one that demands thoughtful and meaningful solutions. As I said at a hearing last month, we all agree that hardworking men and women should be able to earn a paycheck without risking a serious injury or being exposed to a deadly disease. And every family deserves the peace of mind that their loved ones are safe on the job and will come home to them. There's no one in this room who doubts the need for strong health and safety protections, or that OSHA has a role to play in promoting safe workplaces. Reducing occupational injuries, illnesses, and fatalities is a priority that crosses party lines and stretches from the White House to the halls of Congress. However, there are times that when we share a difference of opinion in how to reach that goal. One illness, one injury, or one fatality in the workplace is one too many. That's why, as a committee, we believe bad actors who cut corners and put workers in harm's way must be held accountable. At the same time, the administration should work with employers to address gaps in safety in order to prevent injuries and illnesses before they occur. We also believe health and safety policies should be created with input from the public. Employers and their employees know better than most the unique safety challenges facing their workplaces. They're there. If rules coming out of Washington fail to account for those unique challenges, or if they're too complex and confusing to understand, they won't deliver the protections workers need. That's why the rulemaking process should be transparent and allow for public feedback. Unfortunately, time and time again, the Obama administration has pursued a different, more punitive approach. The majority of employers want to do the right thing, and I truly believe that. But instead of working with those employers to develop proactive safety measures, the agency is focused more on punishing everyone for actions of a few, regulation by shaming. As I said, employers who jeopardize the safety of workers must be held accountable. But the agency's reactive approach does nothing to help employers understand complicated regulations, and it does nothing to achieve our common goal of preventing tragedies from occurring in the first place. Several recent changes to OSHA's injury and illness reporting standards are the latest example of this flawed approach and the focus for our hearing today. These new requirements significantly change who the standards apply to, what needs to be reported, and how and when OSHA must be notified. As is often the case, these changes will create additional layers of red tape, especially for small businesses with limited resources to fully understand complex safety standards. And to make matters worse, the administration has advanced these expensive changes despite broad public concerns. One of the most concerning requirements calls for public posting of injury and illness records online without corresponding context. This regulatory scheme, designed to shame employers, will do little, if anything, to advance the cause of worker safety. What it will do is make it easier for big labor to organize and for trial lawyers to bring frivolous lawsuits. The agency will need to spend millions of dollars on this special interest tool, which will shift scarce resources away from proactive policies to improve safety, such as inspections and compliance assistance programs, VPP, and the like. And in the process, the agency is jeopardizing the privacy of workers' personal information. This rule isn't about serving the best interests of workers. It's about serving powerful special interests at the expense of workers. We owe it to working families to hold the administration accountable for its misguided policies and to call on OSHA to make a more responsible, effective, and collaborative approach. This oversight hearing is an important part of that effort and our commitment to protecting the health and safety of American workers. I look forward to today's important discussion and will recognize the ranking member, Ms. Wilson, for her opening remarks.
Thank you, Chair Wahlberg, and many thanks to the witnesses who are with us here today. Thank you. Mr. Chairman, the Occupational Safety and Health Administration was established to assure, so far as possible, every working man and woman in the nation safe and healthful working conditions. Sadly, every year, tens of thousands of Americans are severely injured on the job with significant, sometimes permanent impact to self and family. Until last year, OSHA lacked information vital for effectively responding to these workplace injuries. In its ongoing efforts to improve workplace safety, OSHA has issued 2 rules to provide transparency about injury and illness rates and to ensure disclosed information is accurate. First, as of January 2015, OSHA requires employers to report work-related amputations, inpatient hospitalizations, or loss of eye within 24 hours. This severe injury reporting requirement is in addition to OSHA's pre-existing requirement to report all fatalities within 8 hours. In the year since this requirement took effect, over 10,000 incidents were reported to federal OSHA alone, including 2,644 amputations and 7,636 inpatient hospitalizations. Ideally, OSHA would inspect each workplace where a severe injury occurs. But because Congress has literally starved OSHA of much-needed resources, the federal agency lacks a sufficient number of facility inspectors. For example, with only 63 inspectors in my home state of Florida, it would take 266 years for OSHA to inspect each workplace in Florida. Despite its limited resources, with 24-hour reporting of severe injuries, OSHA was able to work with employers, asking them to conduct their own incident investigations, report their findings to OSHA, and implement remedies to eliminate hazards and prevent recurrence. For example, while a worker at a Missouri meat processing plant was cleaning a blender, it started up suddenly, amputating both of the worker's lower arms. The employer immediately re-engineered the blender's computer control system, changed safety interlocks, and enhanced worker training and supervision, significantly reducing the risk of amputation. According to OSHA, the worker's arms were surgically reattached and he is undergoing rehabilitation. Under its more recent efforts to protect worker safety, OSHA issued a final rule on May 12, 2016, requiring large employers and those in high-hazard industries to electronically transmit to OSHA injury logs and annual summaries employers are already required to maintain and make available to their employees. OSHA will make this information publicly available on its website. OSHA will not collect personal identifiers. Prior to this rule, most workplace injury and illness logs were only available at the workplace, making it impossible for OSHA, other employers, prospective employees, investors, and public health researchers to know which employers have bad or good injury records. Some object to posting this data to OSHA's website, claiming it could harm reputations and damage businesses. However, under OSHA's 1995 data initiative, 80,000 establishments in high-risk industries were required to provide OSHA with annual summaries. Since 2004, OSHA posted this data to its website and used it to target its inspections to the most hazardous work sites. Under this new rule, however, the universe is expanded to approximately 460,000 establishments. Furthermore, for the past 15 years, the Mine Safety and Health Administration has posted injury and illness rates, allowing mine operators, prospective employees, and current workers to access the information. Indeed, MUSHA posts even information to its website than required under OSHA's new rule, MSHA. I would again argue that responsible employers want to demonstrate to their employees, investors, and the public eye that they are committed to workplace safety. Public disclosure can help nudge employers towards improved safety outcomes. DOL's reporting rules also seek to ensure injury and illness reports and records are accurate. This means addressing the major problem of underreporting of injuries, as recommended by 2 GAO reports for this committee. These GAO reports document how employer policies such as rate-based safety incentive programs discourage workers from reporting injuries. One can easily imagine how programs that cut potential employee bonuses when the worksite injury rate goes up can have a chilling effect on reporting. In addition, the committee will be releasing a new GAO report examining underreporting of injuries in the poultry and meat process industries. To further ensure accuracy of data, OSHA's rules also makes it clear employers may not discriminate against workers for reporting injuries or establish policies discouraging them from doing so. We know that the accuracy of reporting rests on employees' confidence that reporting injuries will not lead to job loss. Mr. Chairman, I ask unanimous consent to enter these 3 GAO reports into the record.
Without objection and hearing none, they'll be entered.
Mr. Chairman, as we begin this hearing, I want to remind all in attendance that we should focus on ensuring safe workplaces for those we represent. Our constituents have families. They have loved ones. They deserve our efforts to come together as the Subcommittee on Workforce Protections to promote and protect safety and healthy workplaces for all Americans. I also want to welcome visiting with me today Paritas from Paritas, West Africa, Paritas Guba, West Africa, from Burkina Faso, West Africa, Paritas Guba. Paritas, raise your hand so that they can see you. She is shadowing me today from West Africa. And I want to thank all of the witnesses for their testimony today, and I yield back the balance of my time.
I thank the gentlelady, and having been to Burkina Faso a number of times, welcome. Good to see you here. Pursuant to Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record, and without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted to in the official hearing record. It's now my pleasure to introduce today's witnesses, beginning with Mr. David Sarvadi, who is a member with Keller and Heckman LLP here in Washington, D.C. and will testify on behalf of the Coalition for Workplace Safety. Mr. Sarvadi represents clients before a variety of federal and state enforcement agencies in legal proceedings involving OSHA citations, EPA notices of violation, and EEOC charges of discrimination. He works with clients in developing, reviewing, and auditing compliance programs in all of these areas and in obtaining agency rulings on proposed or novel activities and questions. Welcome. Ms. Lisa Sprick is president of Sprick Roofing in Corvallis, Oregon, a great place for fly fishing as well, and will testify on behalf of the National Roofing Contractors Association. Sprick Roofing, a family-owned business established in 1952, installs low and steep slope roof systems on both commercial and residential buildings. Welcome. Dr. Rosemary Sokas is chair of the Department of Human Science at the Georgetown University School of Nursing and Health Studies here in Washington, D.C., and will testify on behalf of the American Public Health Association. Dr. Sokas has more than 30 years of experience in the field of occupational and environmental medicine and public health. Welcome. And finally, Mr. Arthur G. Sapper is a partner with McDermott, Will, and Emery, LLP, here in Washington, D.C. Mr. Sapper practices administrative and regulatory law, focusing on all areas of occupational safety and health law and mine safety and health law, regularly litigating before the Occupational Safety and Health Review Commission, the Federal Mine Safety and Health Review Commission, the Federal Appellate Courts, and various administrative bodies. Welcome. I will now ask our witnesses to raise your right hands. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect the witnesses answered in the affirmative. Before I recognize you to provide your testimony, let me briefly explain our lighting system, which is pretty self-explanatory. Green, your 5 minutes continue on till you see yellow, which is a caution light that says you have a minute remaining. And when red hits, please do your best to finish up your statement in the next paragraph or so. We'd appreciate that, and we'll hold our committee to that standard as well. And so let me now ask Dr. David Sarvadi to lead us in his 5 minutes of testimony.
Thank you, Mr. Chairman. Mr. Chairman, Ranking Member Wilson, members, honored guests, and fellow panelists, I'm honored to be asked to participate in this important hearing. Looking back on now the long history of the Occupational Safety and Health Administration, I've concluded that workplace safety and health efforts in the United States have been a great success. I actually started my career prior to the creation of the Occupational Safety and Health Administration, and I spent 15 years as an industrial hygienist in the real world of dealing with these kinds of problems before I came to Washington. From 1970 to 2014, the overall case rate has declined by more than 5 times, and fatalities from 14,000 to 4,800. Of the fatalities, roadway accidents represent 36% of the total, homicides 9%, and aircraft incidents 17%, which means that more than half of all fatalities are related to transportation. Those are areas that most employers don't normally involve themselves in. Obviously, there are employers who do, and those employers have, in many cases, robust programs to address those kinds of hazards. But what I'm pointing out here is that the focus of our attention on workplace incidents and injuries needs to be focused on things that we can actually control and correct. While my remarks will be critical of the path OSHA has taken in recent years, I don't want to be misinterpreted. Workplace safety and health is a very important topic, and I'm not suggesting in any way that our efforts should be lessened. But I am challenging the mindset that suggests it's best seen as a competition between management and labor, more characteristic of 1930s thinking. In 2016, we should be looking at ways to cooperate rather than to be at loggerheads. The Bush administration, in my view, made significant progress in that area, but I think OSHA's gotten off track. The emphasis on enforcement has been overwhelming while the results have been less than impressive. The rate for both fatalities and total cases has stagnated. Worse, OSHA's reputation has reverted to be a poster child of government high-handedness. Only the IRS is likely to have a worse and perhaps well-deserved reputation among the citizens. OSHA's direction needs to be changed. They are exceeding the limits of congressional authority repeatedly and ignoring administrative law guardrails that help preserve our tripartite system of government. Its purpose is to assure that liberty is preserved and government is focused on things that it can control. OSHA has moved far beyond merely establishing reasonably necessary and appropriate standards and regulations to achieve Congress's goal of health and safety, safe and healthful workplaces. OSHA's job is not to save lives, contrary to its relentless propaganda. Congress placed the responsibility for protecting employees on employers, not OSHA. OSHA's job is to make the rules, provide education and support to employers and employees, and for those who fail to do so, surely to enforce to the full extent of the law. The current administration's emphasis on enforcement is misplaced, and training and support have been given short shrift. The proposal and regulations discussed in my written testimony wrongly focus on the details of paperwork, distracting both OSHA and employers from the real task at hand. We have a pretty good handle on the trends in workplace safety statistics. The Bureau of Labor Statistics does a good job of surveying employers using widely accepted statistical techniques, about which I was privileged to be educated as part of a National Academy of Sciences committee. The BLS approach is sound and is constantly being improved by the staff. So unless there's something really wrong with the BLS approach or statistical theory, the trends are well known and will not be affected by OSHA's obsession with counting cases. I wish I could be optimistic in this field, that we could have a real conversation about why things have stalled and what can be done about it. But I have seen no evidence that the current administration is interested in doing so. As evidence of that fact, I would point to the advisory committees that OSHA uses. Few, if any, of the people on the committees depart from the current orthodoxy. Yet technological change long ago overtook practices that have been entrenched only due to intellectual inertia. Here's what I think should be done. The recently adopted proposal should be shelved until the details of the program can be developed in conjunction with employers who will have to use the system. OSHA should be prohibited from publishing the specific case data on injuries and illnesses, and the regulation allowing OSHA to issue citations for retaliation should be rejected by Congress and the courts as a usurpation of congressional legislative authority. For those in favor of these approaches, I remind them eventually people with different viewpoints will be in charge, and they may not like what is then permitted under the loose interpretation of their authority. Thank you again, Mr. Chairman, Ranking Member, for the opportunity to participate in this hearing and for your interest in workplace safety and health. I'll be happy to answer any questions you may have.
Thank you. Ms. Sprick, we recognize you now for 5 minutes of testimony.
Thank you, Mr. Chairman and members of the subcommittee. My name is Lisa Sprick, and I am president of Sprick Roofing in Corvallis, Oregon. I am testifying today on behalf of the National Roofing Contractors Association and appreciate the opportunity to provide the perspective of professional roofing contractors on workplace safety regulations. Sprick Roofing was founded in 1952 and currently has 25 employees. To date, we have worked 1,360 workdays, or more than 5 years, without a time-loss accident, and I believe this speaks to my company's exceptional commitment to safety. There is concern within our industry regarding OSHA regulations and the impacts they will have on worker safety and businesses like mine. I believe these regulations will do little to promote safer workplaces and could prove to be counterproductive to this goal. OSHA's overreaching regulatory approach seems to be stuck in a Washington, D.C. knows best mode of regulating our industry, and I don't believe that Washington always knows best. The first concern I will discuss is OSHA's new regulation to require companies to submit their injury and illness records electronically to the agency. OSHA states that posting these records online will provide employees and others with information that will enhance workplace safety. However, the data as included in the reports lack meaningful context, which is critical to understanding the information properly. Without context, it is unclear how the information being made public will improve workplace safety. Also, misuse of the information by third parties could be harmful to employers. It is not hard to imagine one of my competitors gathering this information and using it to sell against me. Another concern is possible inadvertent public disclosure of private employee information that could cause harm to my workers. Our company goes to great lengths to protect sensitive employee data. As a small business owner, I have many questions about what would happen if this information was inadvertently disclosed. It is also unclear to me what impact the rule will have on employee incentive programs designed to promote workplace safety. I share OSHA's intent to ensure employees must not be deterred from reporting injuries, and our program provides incentives to employees to follow the rules that meet or exceed OSHA standards. We take a proactive approach to safety and even encourage our employees to report near misses so that we can identify problems and prevent injuries from occurring. But this regulation and the other OSHA actions have produced much ambiguity with respect to how OSHA views incentive programs. The expanded authority in this regulation may remove a key tool that employers use to ensure safe workplaces. Another concern with this new regulation is adding unnecessary costs, which is always a concern to small businesses that operate on a thin margin. This is especially true when responsible employers, like my company, which comply with often exceed government regulations, are competing against contractors who not always work under the same compliance of laws and regulations. I fear that adding new reporting burdens that promise unspecified benefits merely diverts valuable resources from risk management strategies and that truly protect workers. Efforts to improve workplace safety could be more effective if OSHA worked with employers on such strategies. Another very serious concern I have is OSHA's recent efforts to impose federal fall protection regulations on states like Oregon. This could jeopardize the safety of workers in Oregon and other states like California and Michigan. I recently learned that Oregon will adopt federal fall protection rules after OSHA demanded our state change its rules or be faced with losing its state plan status. This will limit fall protection options, which may be the most effective in preventing falls in many situations. Oregon rules now allow for more fall protection options, including the use of slide guards installed at the roof edge to prevent falls. My company has been using this option for 63 years, and we've never had a fatality or a serious accident related to their use. We believe that under many circumstances, slide guards are the most effective option for preventing injuries. It is disturbing that OSHA would impose federal rules on our state, given that Oregon's record of preventing falls is better than other states operating under federal rules. I do not understand why OSHA would insist on imposing changes without having empirical evidence that the federal rules are more effective than the state rules. I would urge Congress to prevent OSHA from imposing its rules on state plans like Oregon and similar states unless the agency has data to clearly demonstrate that its rules produce better results that actually protect workers. To conclude, I would want to reiterate that there is great concern within the roofing industry with respect to OSHA's overreaching approach to regulation. It is vital that employers, workers, government agencies, and other stakeholders work together to craft effective safety policies based on sound risk management principles and reliable data. NRCA and its members stand ready to work with Congress and OSHA on efforts to improve workplace safety in the future. I appreciate the opportunity to testify today, and I welcome any questions you may have. Thank you.
Thank you. Dr. Sokas, we welcome you and recognize you for 5 minutes.
Thank you. Chairman Wahlberg, Ranking Member Wilson, and members of the subcommittee, thank you for this invitation. My name is Rosemary Sokas, and I'm providing these remarks on behalf of the American Public Health Association. My testimony will cover 3 areas. First, OSHA's record-keeping rule and its severe injury reporting rule will help prevent workplace illness and injury and improve transparency. Second, there is a need to improve accuracy of information by addressing the problem of underreporting. And third, APHA supports OSHA's efforts to protect vulnerable workers from retaliation for reporting workplace illness or injury. OSHA's new record-keeping rule will bring injury and illness reporting into the 21st century through an efficient web-based mechanism that allows employers to upload information they're already collecting. This rule does not impose any new record-keeping responsibilities, but rather requires the information to be electronically transmitted. Personally identifiable information will not be collected by OSHA, so that should alleviate most of the privacy concerns. Accurate and timely information is important not only to identify problems, but to make sure that solutions work. With OSHA's severe injury reporting program, as you've heard already, the employers are now reporting hospitalization, amputations, and loss of an eye, and OSHA's had the chance to investigate and to encourage the employers to investigate over 10,000 severe injury cases. One example of immediate benefit is that grocery stores, which are only rarely investigated by OSHA, turned out to be a leading locus for amputations. This information helped pinpoint problems with food slicing and allowed OSHA to provide outreach and compliance assistance. In some cases, a single sentinel event may serve to alert the industry to an unrecognized hazard. Public health agencies at the state and local levels will now have worksite data to evaluate the impact of their policies by comparing baseline and follow-up data across a particular industry, as well as by conducting comparisons with states that have different programs or regulations. Industry associations and academics will have access to information across a large enough population to be able to draw meaningful conclusions. OSHA's rule takes needed steps to address underreporting, a problem that's been well reported by GAO investigations as well as BLS as well as academics. NIOSH has conducted a series of health hazard evaluations in poultry processing, where in one plant, fully 34% of the workforce, 64 out of 191 people, met strict case definitions for carpal tunnel syndrome, while only 4 cases had been reported on the OSHA logs during the previous 4 years. When surveyed, 20 workers described work-related illness or injury meeting OSHA's criteria for record keeping, but only one of these incidents was recorded in the log for that year. Aggressive return-to-work policies can suppress reporting. I have reviewed cases in which workers were driven to work on the day of surgery or the day after while still on narcotic medication in order to reduce the days away rate. The OSHA record is full of reports from workers in a variety of industries who receive demerits when they suffer an injury or go through safety and health investigations that focus on punishing the worker, including threats of firing. As OSHA's chief medical officer, I interviewed poultry workers who impressed on me the widespread fear of job loss and a sense of fatalism among many, that they had grown used to living with pain and disability from their jobs. The particular corporation not only failed to protect its workers, but failed to protect its products, was subject to then the largest beef recall in U.S. history, and went bankrupt. High-performing organizations, on the other hand, will encourage the reporting of hazards and near-miss events and reward rather than discipline workers for identifying hazards and solutions. Data collection is not a paperwork exercise. It's a tool to identify problems and ensure that solutions work. I worked in a hospital that tried to reduce needle stick injuries by installing boxes to dispose of the sharps in crowded rooms where they put the boxes too high and the nurses got stuck when they went to put the sharps in. Had those nurses been prevented from reporting by being shamed or criticized, we would never have found out that, in fact, the boxes were a problem and been able to fix the problem. During OSHA's comment period, APHA urged OSHA to recognize and discourage attempts to systematically suppress illness and injury reporting, and even carpenters have expressed concerns about loss of jobs from reporting. I'm going to close with 2 quotes from a researcher at Duke who found carpenters saying things like, quote, "With my company, people are afraid to report injuries even when they get hurt because they will lose their jobs. Not immediately, but in like 2 or 3 months, when it blows over, you're fired." So that's the concern that we are grateful to OSHA for addressing.
Thank you, Dr. Sokas. And I recognize Mr. Sapper for your 5 minutes of questioning, of testimony.
Thank you, Mr. Chairman. Mr. Chairman and members of the subcommittee, I am testifying here about a concern about the rule of law. OSHA is behaving like an imperial bureaucracy. It is trying to do what simple logic indicates is impossible: to extend the statute of limitations by merely amending regulations. In the Volks case, which I had the privilege of appearing in, the U.S. Court of Appeals for the D.C. Circuit held that the statute of limitations in the Occupational Safety and Health Act means what it says, that no citation may be issued following the expiration of 6 months after the occurrence of a violation. OSHA had been issuing citations against employers alleging violations as old as 5 years. The D.C. Circuit said OSHA could not do that, and it spoke unanimously on that point. Nevertheless, OSHA is trying to get around that court decision by merely changing its regulations to state that an employer is under a continuing obligation, when the Court of Appeals said there is no continuing obligation, you can't do that. The court specifically told OSHA that the idea of extending the statute of limitations by merely amending its regulations is absurd and madness. Quote, there is truly no end to such madness, end quote. Not only that, but the United States Supreme Court in the Tusi case held that questions of statutes of limitations are matters of legislative, not administrative decision. So the statute itself, apart from the regulations, must justify what the agency is doing. Most troubling of all, OSHA's proposal, which it has published in the Federal Register, would defeat the core purpose of the statute of limitations, to prevent the bringing of stale charges. Here, the charges would be as stale as 5 years. By the way, in the Volks case, in the years since the alleged violations occurred, one of the record keepers had died, crippling the employer's ability to defend. OSHA's proposal ignores the effect of staleness. So the committee should make clear to the administration that it may not do this. It's also troubling that OSHA has ignored the literal effect of its proposal. As Judge Garland's concurring opinion in the Volks case points out, it would, quote, obligate an employer to constantly re-examine unrecorded injuries and illnesses. But the cost of constant re-examination of unrecorded cases, of every day re-examining whether or not an unrecorded wound should have been recorded, would be staggering. $2 billion, I estimate, for just a single unrecorded case. Yet OSHA itself estimates that the benefit of its proposed regulation would merely be a 1% increase in the compliance rate. The committee may ask why OSHA thinks it may do such questionable things. There are two basic reasons, in my view. First, the federal courts under the Chevron and Auer doctrines have told agencies that they, not the courts, are the authoritative interpreter of statutes and regulations. This doctrine gives agencies enormous power and, in my experience, contributes to their sense of arrogance. For agencies almost never think that they're unreasonable and that they won't get deference. Second, the Office of Management and Budget has an office called Information and Regulatory Affairs, OIRA. But that office has been reluctant to question OSHA's representations that proposed regulations are not significant within the meaning of Executive Order 12866. And that reluctance was particularly striking in this case because OSHA's reasoning on cost made no sense. It completely ignored the cost of what Judge Garland called constant re-examination. And OSHA's proposal clearly met another criterion for examination under the executive order, that the proposal, quote, raises novel legal issues. I submit that whether a mere regulation can effectively override a statute of limitations is certainly a novel legal issue. I thank the committee. I'd be happy to answer your questions.
Thank you, Mr. Saper, for your testimony. Now I recognize the gentleman from Minnesota, the chairman of the full committee, Mr. Klein, for his 5 minutes.
Thank you, Mr. Chairman. Thank you to the witnesses for being here. Excellent testimony. Ms. Brick, you've got a fascinating story, a very successful business. I have a note here that says that Sprick Roofing has worked for more than 5 years without a time loss accident. You told us you have a safety incentive program, and I would assume that this program is contributing to your company's really successful safety record. Could you expand for us how you think that OSHA's actions would hinder your efforts to continue to implement this successful safety program?
Thank you. And yes, we do, our safety program, or safety incentive program, is based on following the rules and regulations that OSHA has outlined, as well as beyond that, things that we have identified through our internal incident reports to track and look at trends of potential injuries and that could occur. I'm afraid that if OSHA takes away those incentives, then my employees will not. The program is incentivizing positive behavior. Is basically what we're doing, and so I'm afraid that taking that away will just give our employees the impression that it's not as important. We also, not only do we do safety incentives, we do quality control incentives, we do all across the board. We do several different things to incentivize our employees to do the right thing and reward their positive behavior. So I'm afraid that that'll be one, since safety is probably the most important of anything that we do, taking away that incentive and that impression that it's not important is concerning to me.
Thank you. Mr. Chairman, I'll yield the remainder of my time to you.
Thank you, Mr. Chairman. I appreciate that. I certainly had plenty of questions I could ask, so thank you. Let me follow on that, Ms. Sprick. Recording an injury is not preventing an injury. I think we could agree on that.
Yes.
Can you explain the safety protocols your company employs to prevent workplace injuries for us?
What we do to prevent injuries?
Yeah, the protocols that you have in place, what are those?
Well, we do a full safety orientation. We do, every job has a particular safety plan that we analyze every job before we go out and look at for the particulars for that job, so that we can be sure that we have all our bases covered. We do safety meetings daily and also for each job. And then we also have job site inspections. Our safety director goes out and does our own internal inspections during the course of the work that's being done to check and make sure that everything that we discussed to be done is happening according to plan.
This is done daily with the employees on the site or back at the office?
The job site inspections or the safety plan?
The safety plan, the safety instruction.
It starts at our office. So it actually starts at the bidding process when we look at the job and we look at the particulars of the job and look at what needs to be done. And then from there, once we get the job, then it starts at the office with the crew before they go out. And then once they go out, then they're inspected on the job as well.
Okay, thank you. Mr. Sapper, your testimony highlights the Vokes decision, overturning OSHA's attempt to issue citations for an alleged violation of Occupational Safety and Health Act more than 6 months old, as you indicated. Does OSHA have the authority to overturn a court ruling through rulemaking?
No, Mr. Chairman, it does not, and I'll be happy to explain why. The Supreme Court has already said in the Tusi case that questions of limitations are statutory questions, not regulatory ones. And as I said before, the D.C. Circuit in the Volks case said that OSHA's attempt to manipulate the result by merely changing its regulations would be, quote, madness and absurd. But OSHA...
Madness and absurd.
Madness and absurd. Now, in fairness to OSHA, the court was talking about a slightly different amendment to the regulations, but the two amendments would have the same effect.
Same principle.
Yes, they would have the exact same effect. And so in principle, they would still be absurd and madness.
Let me ask, why do you believe OSHA is relying on the concurring decision rather than majority opinion in the rulemaking process? Does holding of the case come from majority opinion or concurrence?
Yeah, I think it's, I think the agency understands that the majority opinion of the court is against its position, but it's using the concurring opinion, or it's using what it thinks the concurring opinion says. The concurring opinion said the regulations do not permit OSHA to do what it's doing. So OSHA thinks, okay, well then we'll just change the regulations. What OSHA ignores is Judge Garland's very astute observation that if OSHA tried to do that, it would be imposing a duty of constant reexamination. And OSHA has refused to own up to that effect. In fact, before the Advisory Committee on Construction Safety and Health, when that very question was asked, OSHA said, no, there is no duty of constant reexamination. Well, I'm afraid the agency is being inconsistent on this point. It's not owning up to the actual effect of what its proposal would mean.
Thank you. That was Judge Garland's opinion. I need to move on here. I now recognize the ranking member, Ms. Wilson. Oh, Mr. Scott, excuse me.
Thank you, Mr. Chairman. Mr. Savardi, you indicated in your testimony on page 11 that nothing in the OSHA Act gives OSHA the authority to publish workplace injury and illness data. Is that right? That's your testimony?
I don't believe I quoted that section, but yes, it does give OSHA the authority to publish data on workplace injuries and accidents in aggregate form. It does not address the question of disclosing individual employee conditions.
And you say it's a clear usurpation of legislative power. Doesn't the Act in Section 8, subsection G, say the Secretary of Labor and the Secretary of Health and Human Services are authorized to compile, analyze, and publish, either in summary or detailed form, all reports or information obtained under this section. The Secretary and the Secretary of Health and Human Services shall each prescribe such rules and regulations as he may deem necessary to carry out their responsibilities under this Act, including rules and regulations dealing with inspection of employees' establishment. The language is published either in summary or detailed form. What does that mean?
To me, it means summary form, meaning total accident statistics or whatever the statistics they collect. I believe it refers to the BLS survey, and it reflected at the time the system that was in place that was operated by the National Safety Council. There was some criticism of it by members of Congress at the time, but what Congress was trying to do was improve on what had been the system in place. And nowhere were individual company or establishment data being published by National Safety Council.
I just remind you the words are in summary or detailed form, all reports or information obtained under this section. Is there any information that's required to be published under this rule that's not already being collected?
I don't believe it is, but it's not being provided to OSHA in the detail that they're talking about.
But
It is available to OSHA in an inspection, and it is the first thing that inspectors look at when they come through the door.
But the information is already being collected. Let me ask another question. Ms. Sokas, can you indicate why it's important to collect this data and what data is not being reported because of threats?
So I'm glad to answer that question. I would just like to briefly say
Microphone, is your microphone on?
Sorry. I would just briefly like to say, if I might, that the proactive program that Ms. Brick discussed is actually the kind of incentive programs that the GAO report was positive about in 2012, that the kind that it was criticizing were the ones where people were, it got bonuses based on not reporting illnesses, you know, that kind of thing. So this is exactly the kind of thing that's supposed to happen. The question about the suppression of information through punitive responses to reporting a hazard or reporting an injury shows that, as an example, again, when I did chart review of people who had unfortunately died from being in a confined space with solvents or some other kind of chemical exposure where they were overcome, almost inevitably we would find, or examples in that person's life where they had previously either passed out at work or complained at work. and the early adverse information was not taken seriously, was not acted upon. People were just kind of revived and resuscitated and sent back into the same location, and that's when they died. So this is the kind of thing that you hope to prevent by having the information acted upon as opposed to suppressed.
Is this level of information disclosed now under the mine safety laws?
Oh, absolutely.
And has there been any frivolous lawsuits or any adverse effects?
Not to my knowledge. The mindset, you can go online for MSHA and find all kinds of detailed information equivalent to or more than what OSHA is now going to be publishing. And that information is readily available and has been used by MSHA, which is trying to deal with a very, as you can imagine, the mining industry is among the most hazardous. They're able to actually target effectively and work with employers, and they've had substantial success with that.
Thank the gentleman. I recognize the gentlelady from New York, Ms. Stefanik.
Thank you, Mr. Chairman, and thank you to our witnesses for your testimony today. Data, as we know, has become increasingly present in our everyday lives, from data at work sites to Fitbits, which I happen to not be wearing mine today. We are exposed to endless quantifications of what we do on a daily basis. And this expansive collection of data can be extremely helpful when it is utilized with purpose and context to achieve a needed goal. But we must carefully consider the implications on our nation's small businesses when this collection solves no particular problem. As we know, it serves no purpose to collect the data just for the collection's sake when we should be focusing our efforts on preventing workplace accidents in the first place. Ms. Sprick, in your testimony, you indicate that the data the department is requiring from you lacks important context and therefore will not help you as an employer improve worker safety. Do you have suggestions for improving the department's data collection practices, and how might the federal government better collect context along with the data?
Well, I believe if they're just collecting the injury and illness side of things, it's just telling one side of the story, and they're posting that information. It gives absolutely no context or information about how it occurred, the circumstances, the size of business, the number of hours worked, the part that will give meaning to that information. So if they are just posting that information only, and you're comparing company A and company B, and they each have 2 injuries reported, the exact same injuries, you don't know that company A has 100 employees and company B has 2. So the company B really is the worst company of the 2, but you don't have that context to be able to evaluate that. And to me, that is, one, unfair, and it's not showing the real story. And the other part of it is that then I will have to be trying to defend that if I'm even given the opportunity to, if someone should go that far. They may just look at that information and say, okay, that's all I need to know, and move on. So it's concerning.
Thanks for the comments. I think that continuing to get feedback on the context to make sure that this data is viewed, whether it's the size of business, whether it's the hours worked, is extremely important, because data is one thing, but the context within which the data exists is extremely important.
I mean, the circumstances as well. I mean, if one of my employees slips and falls on the sidewalk, it will be listed as a fall. So the assumption will be made, because I'm a roofing contractor, that that person fell off the roof. So that kind of information would probably be contextual as well. That would be helpful.
Thanks for those comments, and I yield back. Yes, I yield back. I yield to Mr. Wahlberg.
Thank you. I see good time on the board. Pardon. Thank you. Ms. Sprick, let me go on with some practical examples coming from your experience. What are some specific actions that OSHA could undertake, if they were willing, to help your company further improve on its safety program that you defined to me a bit, but how could they help?
Well, I can use the example just in Oregon. We have a very good and collaborative relationship with the Oregon compliance officers in our area. We work with them continually on, sometimes there's a difficult building configuration, that we want to make sure that we're following procedures and that we're interpreting the regulations appropriately. We bring them in we set up a safety plan and get their suggestions and work with them. So it's more of a collaborative effort that I feel that will, in big picture, help everyone in the long run. What I think really should happen is that they should set up a task force with the stakeholders that are involved in that will going to be having to deal with these regulations, bring in the trades, bring in the government, National Safety Council, this people that will have real life experience and know what it's like out in the real world. They're just not sitting around a table and coming up with these ideas and thinking that this is a good one on paper, when in reality, there is no reality. So I think that's the place that they really need to put their efforts, and then also look at employers and incentivize and reward those companies that are doing the right thing versus being punitive and punishing the good ones for all the few bad apples that are out there.
Mr. Sarvardi, OSHA's public reporting regulation also appears to create new whistleblower protections. Did OSHA publish this in the proposed regulatory text, and were stakeholders given an opportunity to evaluate and comment on this provision?
No, unfortunately, Mr. Chairman, they did not. It was added as a supplemental proposal, but they did not include anything about the language that would be used or give people an adequate opportunity to reflect on it. I would point out that they already have sufficient authority under Section 11C. The difference is that under 11C, a complaint initiates the investigation and OSHA's actions. What OSHA is trying to do is create an opportunity for them to issue a citation when they think they have a retaliation claim without waiting for the complaint. I don't know whether that's a good thing or a bad thing. I think that's what the hearings and comments would have
brought out,
addressed if we'd had the opportunity to do so.
The gentlelady's time has expired, and I now recognize Ms. Wilson, ranking member, for her 5 minutes of questioning.
Thank you. First of all, let me thank you, Dr. Sokas, for wearing red today. This is our Wear Red Wednesday. Thank you so much. Your testimony noted that the Government Accountability Office has issued several reports exploring the issue of under-recording of workplace injuries and illnesses. One GAO report examined employer and worker pressure on healthcare providers to downgrade the severity of injuries in order to ensure the injury would not be classified as an OSHA recordable incident. What did GAO find, and is this something you have encountered?
Thank you.
Share with us.
Thank you. Yes, I'm a member of an active member of the American College of Occupational and Environmental Medicine, and it's been on the radar screen for our members for years. The GAO found that over half of the healthcare professionals who were surveyed had experienced some pressure from management to downgrade the treatment being offered in a particular instance in order to make it not a recordable. Use steri strips, not sutures, that kind of thing, to the point where they felt uncomfortable. Almost half felt the same pressure from the employees, and as a practicing physician, I felt the same thing, where the workers are too afraid to have either a workers' comp case filed or to have anybody call their work site because they are afraid of being fired, of punitive responses. So the pressure from both the workers and from the employers has impacted the practice of occupational medicine, occupational health nursing, and other people as well, the clinicians in general. I did also want to mention that I think the detailed information on context for reporting is available already in the 301, and that's what the larger companies are now being required to submit. So the fact that the smaller ones aren't being required to submit it, I'm not sure. I don't think it would be difficult to submit it voluntarily if people wanted to do that, to address that one concern that was raised.
Exactly. GAO issued a report in April 2012 and called upon OSHA to clarify its guidance on safety incentive programs. Did GAO find that safety incentive programs that are tied to low injury and illness rate may lead to underreporting? And how has OSHA accomplished this in its rule?
Exactly. That's exactly the distinction between the good incentive programs that encourage people to recognize hazards and do something about them and get training, and the bad programs that are based on a single number that encourages people not to report the injury, not to report the illness, because somebody's going to lose money in their bonus, or somebody will lose the ability to participate in a positive scheme. So OSHA in this report, in this rule, is very carefully making the distinction between those two kinds of incentive programs, and saying that the ones that have the effect of chilling, of reducing people's willingness to report, are the ones that they're going to look at carefully. The other incentive programs that promote healthy recognition of hazards and solutions to them, they obviously encourage.
It appears as if opponents of this rule contend that underreporting is not systemic. It's not a systemic problem in American workplaces. They also claim that OSHA has been unable to establish that employer policies such as safety incentive policies, post-accident drug testing, or disciplinary policies in any way discourage employees from reporting injuries and illnesses. Is OSHA chasing a non-existent problem? What do credible studies tell us about this?
There are numbers of studies from the academic and from the GAO reports that you mentioned, from the Bureau of Labor Statistics itself, that show that systematically there is underreporting in OSHA illness and injury logs and in BLS data itself. It varies depending on the methods that are used, but if you go to a workplace and interview workers, or if you take any kind of survey where you interview people and ask the questions, you will always find under-recording in the OSHA logs, because for a variety of reasons. Either people don't want to report to their supervisors, or the supervisors don't want to record it, or for many different motivations. But the information is, there's always a difference there in all of the studies.
Thank you. Mr.
The gentlelady's time has expired.
Okay.
And now I recognize Mr. Pocan for your 5 minutes.
Thank you, Mr. Chairman. Appreciate it, and thank you to the witnesses. I'm usually not too much at a loss of words at a hearing, but this one, I have to admit, I am a little surprised that there's opposition to this rule. Specifically, I know it was mentioned that we feel like we're back in the 1930s. I was thinking more a little before that, at that turn of the century, when workers had absolutely no rights and we didn't record these sort of things, and there was no recognition whatsoever. When I hear people talking about OSHA and the madness and the arrogance, and how after 6 months something is stale, losing a limb is not stale. After 6 months, losing a family member is not stale. Those words seem to drip in a little bit of arrogance, and I do have a little bit of non-understanding in that. I do have one question, Mr. Savati. I know your association is largely funded by the U.S. Chamber and NAM, and both of those organizations opposed the creation of OSHA in the early 70s. Do you know, do those organizations still oppose the creation of OSHA?
I don't recall that they opposed it, and I don't know what their position is.
Oh, no problem. All right, thank you. I'll reclaim my time. That's part of the, I reclaim my time, sir. Thank you.
If I could.
No, actually, I reclaim my time. Thank you. The problem is both those organizations did. And I understand that they have a beef with the overall concept, and you said, you know, it's not their job to save lives. I looked at the mission of OSHA very clearly. I think the public expects, and you read the mission, it is to make sure you're saving lives. And of course, that does happen through the employer. And I really am most sympathetic to Ms. Sprick, because you list your concerns. I'm a small business owner as well. And I look at the things that you brought up, and I think what came out of the hearing, sometimes people like to create fear among small business owners, and they come here, and I'm just really glad that we have a small business owner. Usually they just bring us lawyers, and they all get paid to say stuff. You and I are just trying to, you know, make sure we're employing people and doing a business. But some of the things you brought up, I think, did come out, you know, around the inadvertent public disclosure. for individuals, that information won't be collected. So we don't have to worry directly on that. On the meaningfulness of the context of the information, if you're over 250 employers, you're going to have that incident where you'll write down if it was a fall, but there's going to be more written about it. So you're going to have the broader context. If you're under 250, which I would assume are most of the roofing association members, at least they are in my district, they're not 250 employers or more, it's not even mentioned a fall. It's really very much days lost data. It's a simple line listing that's published. So I don't think you're going to have that problem that's out there. And for the bigger employers, they will have the rest of the context of information put there. And I think that's going to be very helpful. I believe there was a concern about the misuse harmful to employers. I understand you're saying, but if at the same time, I look at the comments from the former head of Alcoa who talked about why this has been good for his business. In fact, he said when they had someone who passed away and that made them really look at their what they did, and during a period of 13 years that he was there, they dropped the rate from 1.86 to 0.20 loss, and their market value jumped from $3 billion to $27 billion, and their net income went from $200 million to $1.48 billion. So I think what the context of the person's comments is, it actually made them focus on things. And I think if I go to New York City and I want to have Thai food and I see 2 Thai restaurants, one's got an A and one's got a C, unless they have really, really good Thai iced tea that I've known that's worldwide at the C, I'm probably going to the A, and that's part of why we collect that information. So I think many of your concerns will probably be more addressed, and I think the fear factor is out there. I do have a very specific question, though, for Dr. Sokas. You started talking about the one example with the nurses, and I think this has been collected now for a year. Can you provide how this rule is having a difference? Do you have some examples that you could offer? I think that might be helpful in the full context.
Sure. There's a great report that that OSHA put out. David Michaels wrote about what's happened with the 10,000 serious cases that that the ranking member already alluded to. One of the companies, for example, had a hospitalization for a heat stress injury, and then they went back and they decided to change their rest breaks. They had water available. They started installing fans. It was a waste company. Another company had the problem with the amputations, as you heard, and what they did was they went back and they installed guards. So the goal of all of this is to find problems, have the employer, wherever possible, find and fix them, and then share the information across the industry so other people don't have to wait and experience their own tragedies before they can identify a problem and then fix it. So the report is full of those kinds of examples. I think OSHA used its scarce resources to go out to maybe 40% of the locations reporting, but fully 60% or more wound up having the employers themselves respond and fix it before the next person could lose an arm.
Thank you.
I thank the gentleman, and now I recognize the gentleman from California, Mr. Gisagnier.
Thank you, Mr. Chairman. I want to thank the witnesses, too, and like my colleague from Wisconsin, having owned small businesses, restaurants for many years, I always struggled with my aversion for unnecessary regulation and the overhead that caused, versus what Mr. Kane said, that if you do the right thing, you don't have these problems. And I had a bigger problem with competitors, usually larger food restaurant companies that clearly were on a path to the bottom. So, Ms. Sprick, my sort of frustration is, if you do the right thing, as you do, in your industry, certainly in California, we had a lot of evidence that in the roofing industry, there are a lot of non-licensed contractors who weren't paying workers' compensation, weren't paying payroll tax, and you are doing the right thing. So certainly there is a general conveyance or confluence of interests where, in your interest for your company and other companies like this, you want to get rid of those people who are non-licensed and aren't doing workers' compensation, much less reporting those incidents. Could you just comment on that?
Yes, and we have the same problem in Oregon, unfortunately, with unlicensed contractors. It's not only the reporting part, but the non-context, if they're unscrupulous in business practices, they're going to be unscrupulous in how they're going to use that information.
Correct.
And how they're going to take that information out of context and use it however they see fit. And that's my concern. So the concern is not going to, not only how the accident itself, but the context to the size of business, how long they've been in business. You're just looking at one side of the story, and that can be, as we all know, how one side of the story can be swayed in any way, shape, or form that you see fit. That is my concern. My greater concern is that the reporting, the electronic reporting of this is going to provide another conduit for breach of potential privacy that I protect fervently in my company to protect my workers. So you're exposing me to another way that I could be either myself up for liability, but more so that my workers could be, their private information can be accessed either inadvertently, and the rule that I saw, it said that the information will be redacted. It doesn't say it won't be collected, and that's where my concern is as well. But
if I could just interrupt, Dr. Sokas, could you respond to that? There is a, there are contentions, not just as just been expressed, but that there'll be frivolous lawsuits because of this information. I understand it. The department's for 10 years has gotten information from 80,000 employers. I'm just wondering if you could respond to both the concern, but also the fact that we've already been doing this for some period of time and it doesn't seem to have led to frivolous lawsuits.
So two things. One is that my understanding of the rule, I think there's a little confusion because there's this one pager that I think says it differently, but my understanding of the rule itself is that they're not going to collect those pieces of information, the worker's name, address, all of those pieces of information would not be collected, and certainly not from so they're not collected by anybody, even the large businesses. So that's not really, it shouldn't be a problem at all. The issue with MSHA is even when they do present information that's available that you can go online, I'm unaware of any times when they've been sued or one, mining company has gone after another. I mean, there's a lot of other stuff that goes on in mining, but that's not one of them.
Could, Dr. Sokas, maybe you could explain, is there anything else that this information will help you in terms of research for prevention?
Oh, there's a ton of stuff. So, for example,
let us know a few of the things.
So one, for example, is there's a lot of places that are going to green cleaners, for schools, for hospitals, for all kinds of places, to be more sustainable environmentally. And the problem is you don't really know if the new procedures are better or worse for the people who are doing the cleaning. So there's microfiber mops that use less water. Does that reduce musculoskeletal problems or does it increase them? Now, unfortunately, we don't have a musculoskeletal column, but nevertheless, you could do total injuries to see, across this whole industry, all these people are using green cleaners. Do they have fewer respiratory complaints? Do they have fewer skin complaints? Those kinds of things. Because currently, you have to have a research assistant or a student, or you have to kind of traipse out to the place, talk to the people, get the information, and it's virtually impossible to do it on a scale that would allow you to get meaningful statistics.
Thank you. I yield back.
I thank the gentleman. Recognize myself for 5 minutes of questioning. Mr. Servati, safety experts discussed the difference between leading indicators, such as preventative risk management tools, lagging indicators such as injury and illness rates, leading, lagging, which indicate when a worker has not been protected. Do you agree that injury and illness records are lagging indicators?
Well, they are, most certainly. We're looking in the rearview mirror because we're only looking at what happened in the past.
Should OSHA be relying on lagging indicators?
Well, I would say OSHA probably ought to listen to its own advice. They've been telling employers for more than 10 years that employers should be providing and looking for leading indicators and should be focused on the leading indicators. So I think they might take their own advice.
Hard message, but appropriate message. For calendar year 2015, I was struck with the fact that OSHA received fewer than 11,000 reports of hospitalization and amputations, significant problems, while the regulatory proposal suggested OSHA would receive 117,000 OSHA believes the fiscal year 2015 reports represent only 50% of annual occupational injuries. That's a lot of cover, if that's true. Have you seen any evidence from OSHA or other studies that would justify OSHA's assumption?
I have not. I think the numbers that they're seeing are probably realistic based on my experience over the years in paying attention to the trade press and that sort of thing. So I think the numbers that we're seeing are probably very realistic in terms of what's actually happening.
We would certainly conclude there might be some out there. I mean, we've
course.
heard testimony already that there were contractors, there were construction workers under the union representation who indicated that they held back reporting because of fear of being hurt on the job or being fired, and yet they had union representation to protect them from that. So that seems a little bit strange, that would be an actual experience that would be something that OSHA was hiding.
I think the point that I was trying to make in the testimony is that we're focusing an awful lot on keeping track of things that happened in the past and not taking advantage of what we know already to look to make corrections in the future. The anecdotes that we've heard about these things being underreported, misrecorded, certainly those kinds of things happen. Given the number of questions that we get in our office from people in the employment community who are asking, is this case recordable, how do I record it, suggests that there's bound to be some errors. My point is, if the BLS approach is correct and it is statistically reliable, then all of this effort to generate more information about underreported or misrecorded cases is not going to change the outcome. It's not going to change the understanding of what the real significant problems are. And what I would suggest is that OSHA take advantage of what it has right now and refocus its efforts to begin looking at ways for employers to work together with their employees to come up with better systems like the one that Ms. Sprick has talked about.
Okay, thank you. Ms. Sprick, can you tell what you do to protect your employees' personal health information?
Oh, can I? I'm sorry, I didn't hear what you said. Yes, for a hard copy, they have separate medical files that are stored in separate locked filing cabinets in a separate locked fireproof room within our office that has security cameras and is also monitored with security systems. Our electronic data is our firewalls are continually tested for hacking, which was my other concern, which not only inadvertent disclosure, but intentional hacking is a very large concern of mine, as it should be all of ours. We hear it in the news almost daily. My IT guy is a former professional hacker, so companies actually hired him to sit outside their office and see how long it took him to get into their systems. So that's my guy that protects my electronic data from anyone passing by and being able to access it. So those two things are the way I.
So this would cause you some concern going the direction that's going away from the protection that you're providing, including using a professional hacker.
Yes, for me, it's one more conduit for someone to be able to access information that's private, and also the concern about the information being redacted. I'm a small company. If one of my guys breaks their ankle and it's posted on a website saying that someone from Sprick Roofing broke their ankle, it's pretty easy to figure out which guy that is. So their personal health and privacy has, been breached, in my opinion. So that's another way that I'm concerned.
Well, thank you. I want to thank each of the witnesses for your time and attention. You've been a valuable reference tool and experience tool for us today in developing our context and our understanding of what's going on. But our time has expired, so now I recognize my friend and colleague, Ranking Member Wilson, for her closing comments.
Mr. Chairman, the law is clear. Section 8C2, Section 8G, and Section 24A of the OSH Act expressly tasked the Secretary of Labor with, number one, requiring reporting and record keeping on serious workplace injuries, number two, ensuring this information is accurate. And number 3, compiling, analyzing, and publishing, either in summary or detailed form, all reports or information obtained under this authority. OSHA's record-keeping rule is clearly grounded in this statutory duty and will promote safer workplaces. This rule will give OSHA the ability to more quickly identify hazards and target its limited funds to prevent injury reoccurrence. Publicly available injury data will also help workers better advocate for improved safety conditions. It will allow responsible employers to better understand and develop ways to mitigate workplace hazards. We must reject arguments that workplace safety, transparency is incompatible with good business. Nothing refutes this point more than the work and words of Paul O'Neill, former Secretary of Treasury under George W. Bush and former CEO of Alcoa, a global leader in aluminum manufacturing based in Pittsburgh, Pennsylvania. In a recent op-ed, Mr. O'Neill wrote, "Don't fear transparency, embrace it. A focus on safety, even in the glare of public scrutiny, will not only help your workers, it will also improve your bottom line." Mr. O'Neill, upon taking the helm of Alcoa, made a now infamous inaugural speech declaring his commitment to worker safety that would catapult Alcoa's profits. In the 13 years, Mr. O'Neill made worker safety and transparency mission 1. Alcoa saw its market value climb from $3 billion to $27.53 billion, and net income soar from $200 million to $1.484 billion. Today, Alcoa's corporate website publishes real-time injury and illnesses rates. As Mr. O'Neill states, bottom lines and safety transparency are definitely compatible and sustainable. Mr. Chairman, I ask unanimous consent to offer into the record an op-ed from Mr. O'Neill entitled, "Don't Fear the Injury Data."
Without objection, it will be entered, and hearing no objection, it is done.
The OSH Act clearly states that the Secretary has a duty to ensure the accuracy of workplace injury records and reports. This rule ensures accuracy by addressing underreporting that stems from fear or retaliation for reporting. As we've heard, workplace safety incentive programs, although sometimes well-meaning, can actually undermine safety by discouraging employees from reporting injuries. More egregious policy and procedures punish workers instead of focusing on addressing workplace hazards. For example, I have a warning note sent to an employee after he sustained several injuries over a 3-year period. This note chastises the employee and clearly discourages reporting. It states, "The worker demonstrates a serious lack of attention to the worker's own safety. The employee was suspended for 3 days, stripped of operator classification, and warned he would be fired should he have another OSHA recordable injury. There is no mention of working with the employee to better understand the cause of injuries or to efforts to prevent injury reoccurrence. Just blame, 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 blame for the worker." I ask unanimous consent to enter this warning notice into the record.
Without objection, it will be entered.
I applaud OSHA for finalizing rules to improve worker safety and increase transparency. No working American should head off to work wondering if today is the day she will sustain an injury that seriously impacts her life or takes her life. No mother, father, son, or daughter should dread getting a phone call informing them that their loved one has been seriously injured on the job. We should support OSHA in its efforts to promote the better injury and illness reporting that leads to safer workplaces. Instead of holding hearings attacking OSHA's efforts to promote worker safety, let's hold hearings on ways we can support OSHA by increasing its budget for better enforcement or passing H.R. 2090, Protecting America's Workers Act, to strengthen OSHA's ability to protect workers. Finally, Mr. Chairman, I ask unanimous consent to place into the record letters in support of OSHA's rule from the following organizations: Public Citizen, American Federation of State, County, and Municipal Employees, AFSCME, United Steelworkers, Harvard Kennedy School Center for Democratic Governance and Innovation, and the United Steelworkers. I yield the remainder of my time.
Without objection, they will be entered. I thank the gentlelady, and I thank again the panel that has been here, as well as my colleagues in taking action or taking part in this hearing. As we started out the hearing, I think we made it very clear: a Democrat, Republican, employee, employer, bureaucrat. There is no one that I've met that wants an unsafe workplace. There is no one that wants to see employees injured in the workplace that wants to succeed in the workplace or as an employer. We are not, thankfully, in the 20s and 30s, or even in the 60s, as I remember working at U.S. Steel in a plant that had carried on for many, many years, but the workplace conditions are not what I see now. At least from my perspective of taking 149 workplace visits this last year, myself in my district, and seeing workplace environment in steel mills, in manufacturing sites, in small businesses that don't compare to what went on in the past. They are clean, they are up to date, they are safe, and they, frankly, are always in an effort of improving. We certainly don't fear transparency. We want transparency. We don't fear accuracy in reporting. We want accuracy in reporting. We also want our regulators to understand that there are best practices that are better than anything that are being offered, and there is a context that needs to be considered as well if you're going to have transparency and accuracy. And when you refuse to take the advice or even offer the opportunity for people who live and work and provide jobs and do those jobs in the real world, you've got a problem that's developed. We saw the ability even, I believe it was 3 years ago, when we had a hearing in this subcommittee on fall protection. And we had real-world testimony coming from some of our committee members who were in the industry and knew what went on, and like Ms. Sprick, had an unbelievably good safety record, and were able to instruct OSHA on the fact that they were going to hurt people if they took a one-size-fits-all plan on fall protection. And we saw them thankfully back away. They heard good advice with context, with accuracy, with transparency. We are, however, in the 21st century with something we didn't have back in the 20s and 30s, and even to a great degree in the 60s, and that's global competition. Massive global competition that don't deal with some of the things that we put in the way of, in certain cases, success for our own industry. We all saw last year $1.9 trillion annual cost to our employers simply for regulatory compliance costs. Now, we need certain regulation, but we also need to understand that if we overregulate or we regulate without rationality and regulate even worse without context that promotes the value of that regulation, those costs will increase. And those costs aren't found in our competitors. They have to come up to our standards. But right now, they're just trying to beat us. Partnership is what we're looking for. Best practices primarily developed by business and industry and leading the way for regulators to understand. Pushing things like VPP. There's a partnership that allows both sides to learn from each other. But rather than going that direction, we continue to push for more regulation for regulation's sake, without consideration of context and reality. And to my colleagues and others in the room, that's what this hearing is about. Not trying to make the workplace less safe or give special benefit to employers over employees. It's rather to make the workplaces safe with rational, transparent, and accurate regulation that comes in. And so I again thank each one involved this morning for this hearing. And hopefully OSHA and other regulators are listening to our concerns and the reality that comes in life itself. With no further business to be carried on by this subcommittee, the subcommittee stands adjourned.